Hello, ladies and gentlemen. This is William Hindman, your host, and this is Just Force 911, where we look at how our public officials do their job or they just screw it up. This is about a judge this time who thinks he knows the ADA laws and doesn't have a clue what the hell he's doing. It's incredible. I just don't get it. How can these people be in office when they don't know what they're doing? Anyway, guys, do me a favor, subscribe if you would. Um, Hit the share and like button. It helps my algorithms. Thumbs up, thumbs down says how I do for you. Leave me a comment and subscribe. And this video comes from Certified ADA Adversary. Go check him out. See if you like his stuff. There's a whole lot of ADA stuff there. And check him out and see if you guys like it. Tell him I sent you guys over there. All right, let's get on with the video.
So when a judge is incompetent to administer the ADA correctly, everybody's harmed. And so this morning, I had a judge in North Carolina, Judge Jeffrey Moreland, who thought they knew what the ADA was. And when I challenged him on what his authority was, he choked. Let me show you.
What it is I think that we need for a medical documentation is a letter that tells us what's the nature of the impairment, that identifies the major bodily functions or life activity that's limited as a result of the impairment. How does that impairment affect each major life activity specified above? And to what extent does the illness or condition limit that major life activity? What mitigation measures does the medical professional recommend? And how long does the medical professional anticipate these modifications to be required? And so this appears to be insufficient. Do you want to tell me anything about that?
Here is reading from a form, not from the ADA. He's reading from some form that was made up that is not ADA compliant because the ADA does not support requiring medical documentation so that you can have accommodations. 28 CFR 35.101, Title II of the ADA says that whether or not an individual meets the definition of disability should not demand extensive analysis. And there is no requirement in Title II for medical documentation to support a request for accommodations. And under 28 CFR 35.164, the court actually has a duty when they receive a request for accommodations to respond in a certain way, to examine all the resources they have available. And if they're going to deny, to either claim fundamental alteration or undue burden. That has not been done in this case at all. And they're also to respond in writing, but that hasn't been done either. But as far as the medical documentation, there's no authorization in the ADA for Title II covered entity to require documentation. There's an 11th Circuit case called Sugg versus City of Sunrise that came out in 2022, and it's a Title I ADA case, which is employer-employee. And the appeals court said Sugg, which was the employee, was entitled to have his testimony heard as a triable fact for whether or not he was disabled. And the employer was saying, well, his testimony was self-serving and we can ask for doctor's documentation. But the appeals court in that case said, you know, you're supposed to give him weight when he says, I have a disability. So when you say it's insufficient, I don't know of any case law or ADA final rule implementation that supports having a requirement that a medical professional document that a disability exists. And Dr. King did say that the accommodations that were requested were reasonable. So
I understand, and I think we just have a disagreement on what it is I'm allowed to request. And we have disagreements all the time in court, and if we disagree, you can file whatever you need to file for that. But to me, it appears that Mr. and I hope I don't pronounce this wrong. Is it Dr. D.L.?
Dr.
It appears he's just rubber stamped your motion, essentially. And so I am going to find that it's insufficient, and I will give you a chance to present more sufficient medical documentation if you wish. But without that, I am not inclined to modify the way that we operate. Okay.
So what's
send
your
out an order in writing, and we will give you a copy of that, okay?
What's your authority for requiring medical documentation?
My authority on requesting it is Title II.
Title II of the ADA, what section? I've been doing this for almost
That's
8
correct.
years.
So I have spoken with our general counsel, and what I find very dispositive is we actually don't have a policy on it, but the state of Vermont has a published policy, and that is where I looked at to guide me through this. And in speaking with my general counsel and looking at the Vermont policy, it appears to be all this is valid case law. And so that's fine if you don't agree with me. I'll send my order, and you're welcome to appeal it to whatever entity you would like, okay?
So you're saying you checked with the state of Vermont, but I still don't have an authority that says you can require or even request.
I am saying that I found their policy helpful, and when I researched the case law and I spoke to my general counsel, I found a lot of cases, including Mazzano versus 2nd Judicial District Court in Nevada, which you were the advocate in, and found that you filed those motions in bad faith and were frivolous. And so in light of that, I'm going to deny this. I will send you a copy of that order, and I'm going to direct the clerk to end this.
So when I challenged this judge to produce, I said, where do you find the authority? He said in Title II. When I asked him to produce the authority in Title II, what specific section of Title II? He said, I talked to my lawyer. Then he said, I pulled from the state of Vermont their policy because we don't have a policy. So if North Carolina doesn't have a policy, they can't use another state's policy as their own without it going through the proper channels. And this guy just pulls it out of his ass, and I don't even know, he didn't even say what the state of Vermont policy was and how it related to what we were talking about. So that was vague. And then he pulls out this Mazzano case in Nevada where the judge said I was guilty of practicing the law without a license and that my actions were frivolous. And he reported me to the state bar. State Bar of Nevada, and I've published this before, came back and said, yeah, we're not going to say, they didn't say, I'm going to put the letter here, but they said, we're not going to say you're, practicing law without a license. They refused to do that. And they also said, we're not going to pursue this at this time at all. So they didn't come after me, even after a federal judge referred me to the state bar. So this guy in Nevada, here's the thing. I'm in a business where I go up against judges, and they're going to come against me as well. And I'm okay with that. I'm going to go harder every fucking day until I die because of judges like Jeffrey Moreland, who is incompetent as fuck, doesn't know his ass from a hole in the ground. And these judges, when you ask them to prove what they're saying to support their position, they have no accountability. That's why I say judges are crybaby little punks. Because this guy can sit on the bench and say stuff, and then when you ask him to back it up, he just shucks and jives and goes all around and doesn't have an answer. And yet he's going to shut me out. So this is what the ADA, the state of the ADA in today's court, this is what, and if you're going in by yourself, it's going to be 10 times worse than this. Just letting you know.
Okay, guys. So, what do you think? What's your opinion on the ADA? Because I know for a fact that if they don't have a ruling on their books, they can't just borrow it from another state. It doesn't work that way. Sorry, it has to go through the legislature and all that good garbage. All right, guys. So let me know, and we'll talk to you again on the next one. Thanks.